Hello everyone, welcome back to lecture 8 of CPC by Dhruti Dhere. In today's lecture, we will be covering topics of withdrawal and compromise of suits, effect of death, marriage and insolvency of parties, and special suits. So I hope the last class, whatever we had dealt is clear to you, and whatever topics I had listed that you can go through them. There you do not need me to go into them into detail. If you want, still the option is open. You can let me know and we can cover those topics as well. So without any further delay, we should now move on to the first topic of today, that is withdrawal and compromise of suits. Now, where it has been dealt first, whenever we read something, first we need to see the provision. So that is Order 23. Where withdrawal can be of two types. First, you're taking the leave of the court or you're not taking the leave of the court. So rule 1 under Order 23 is telling us where there is withdrawal of suit or abandonment of part of the claim. So anytime after you have instituted the suit, the plaintiff against all or any of the defendants can abandon his suit or part of the claim if a minor or any person to which Order 32 is extending. In those cases, there will be no abandonment without taking the leave of the court. Here, the application that you are giving for abandoning or withdrawing the suit, it should be having an affidavit of the next friend of the pleader that yes, this abandonment we are trying to effect, and whatever abandonment we are doing is for the benefit of the minor or such person. And if the court is satisfied that if the suit will fail for formal defects, like there was a want of notice under Section 80, non-payment of court fee, etc., or that is a defect which is not affecting the merits, or there's a sufficient ground where they can allow that, okay, you go withdraw, and you can withdraw and you can institute a fresh suit in respect of the same subject matter. There, the court may grant that permission to withdraw and the liberty that you can come back with a fresh suit. However, if that particular plaintiff is not taking permission and abandoning or withdrawing the same, the court can not only award costs, but you will also be precluded from filing a fresh suit in respect of the subject matter or the part that you have withdrawn. And nothing under this rule will empower if there are several plaintiffs, one cannot abandon or withdraw a claim without taking the consent of the others. So this was that if you are taking the permission, then you and the court is giving you the liberty that, okay, withdraw and file a fresh one, then there you can do so. But if you're withdrawing without the permission of the court, in those cases, it is not possible for you to put in a fresh suit for the same thing. And for a minor, you should know that you obviously, because that is a person, minority is a legal disability, and there the court is extra cautious that nobody is trying to take advantage of the disability that the person is laboring under. That is why that affidavit and all that this withdrawal is for the benefit, etc., has to be given. Now, Rule 1A is where transposition of defendants as plaintiffs may be permitted. Now, if under Rule 1, there's a withdrawal or abandonment, then the defendant can apply that, please transpose me as a plaintiff under Order 1, Rule 2. That is, the suit was in the name of the wrong plaintiff. Now make me a plaintiff. And then while the court is considering such an application, the court will see whether the applicant has any subsequent question that needs to be decided against or any of the other defendants. Now, what is Rule 2 saying? That if fresh suit's permission was given and you're going and instituting, then you're not bound by the limitation law. It will be taken that you had come before the court in the limitation period. And after institution of suits, obviously you can go for compromise or adjustment or by agreement. Now, Rule 3 is telling us about the compromise of suit. When it is proved to the satisfaction of the court that a particular suit has been adjusted in whole or in part, how? By a lawful agreement or compromise in writing, and the same is signed by the parties, or the defendant has satisfied the plaintiff for whole or part, or satisfied the plaintiff for whole or part. Such agreement, such compromise, such satisfaction can be recorded, and in respect of the same, a decree can be passed in relation to the parties to the suit. Whether or not the subject matter is the same, the parties should be the same, subject matter or not is the same, that doesn't matter. But if a compromise or an agreement or a satisfaction has been done by the defendant, same can be recorded and a decree can be passed. However, if one party is alleging that yes, such an agreement had taken place, another party is denying the same, court will have to decide on the same, and for deciding on the same, no adjournment is needed unless court accorded reasons, grant such an adjournment. However, just because any kind of an agreement or compromise is being allowed, that does not mean that it will be a void or a voidable agreement. Now, Rule 3A states bar to suit. Now, you cannot go for a suit to set aside a decree on the ground that the compromise on which the decree was based was unlawful. And 3B is saying no agreement or compromise can be entered in a representative suit without taking the permission of the court. And the same has to be expressly recorded in the proceedings. If you are doing so without taking the court's permission, it will be void. And obviously, it's a representative suit. Lots of people's interests matter. That is why the court's permission is needed. And before the court will grant permission, the court may give notice to the persons it feels that are required, who it feels are interested and need to know that such and such thing will be happening. And what are some kinds of representative suits? Order 2192, Order 1 Rule 8, where there's a suit of a Hindu undivided family, where the manager, one person is representing the family or anything other. Now, compromise decree is as such, because it was not heard and finally decided by a court, it will not work as res judicata. However, it operates as an estoppel. This is why, and it operates as an estoppel, and execution of a compromise decree is always done in the same manner as an ordinary decree, and no appeal lies to set aside such a decree when it is done with the consent of parties. Naturally, we have to understand logically also, if both the parties had come together and decided, okay, this and this are the conditions on which we are drawing up a compromise, later on, because you had done it on your own, so no such appeal should lie on the ground that no, this decree was passed falsely. Now, this was the first topic, withdrawal and compromise of suits. So there we saw two main headings. Rule 1, we saw when you're withdrawing or abandoning a part of claim. One important thing, with permission, without permission. With permission, then you may be allowed to file a fresh suit. If it is without, then you obviously are precluded from filing a fresh suit. That is the most important part. Rule 1 is for the transposition of the dependent. Rule 2 is when you are instituting Rule 1 and 2 for the withdrawal part, Rule 3 about the compromise, the bar to suit, 3B about no agreement or compromise to be entered in a representative suit without taking the leave of a court. So this, all this Order 23 that you are seeing, you have to read it in two portions, first for withdrawal and second for the compromise part. I hope that is clear, and we can move on to the next topic. Now, as we have seen till now, we have seen a number of concepts. We saw how, when will you withdraw, when you will compromise, etc. Now, what happens if a party is dying? What happens if a marriage has taken place? Or what happens if an insolvency of parties has happened? Now, here, what is the relevant order? The relevant order over here is Order 22. Now, there, as you can see on the screen, there are 4 subtopics that are tried to divide it into. Death is dealt under Rules 1 to 6, marriage under Rule 7, insolvency 8, assignment of interest under Rule 10. Now, there will be a word that will be coming that means right to sue, which means right to seek relief. Now, generally, before beginning with the death of a party part, it is taken that a right to sue survives to its representatives, but for personal action, it does not. It will die with the person. And you can see the Latin maxim there. Now, you cannot go and file a suit against a dead person. It will be non-est. It will have no legal effect. Now, moving on to Order 22, when the first topic, that is death of a party. Now, Rule 1 says that the suit will not abate if by party is dead, there is a right to sue is surviving. So if a right to sue is there, suit will not abate if somebody has died. Now, Rule 2 says that where there are one of several defendants or plaintiffs, if a plaintiff is dying and there are other plaintiffs and the right to sue is surviving to the surviving plaintiffs, etc., or if it is a dependent and it is surviving to the other defendant or dependents, court will cause an entry made to that effect and will proceed with the persons who are now surviving. Now, the third rule is saying death of one of the several plaintiffs or sole plaintiff. In this situation, where if there are several plaintiffs, one plaintiff has died and the right to sue does not survive to the others, or right to sue survives on the death of the sole plaintiff, In these situations, the legal representatives of the deceived plaintiff can be made party to and may proceed. Now, if no application is made within the time limit, suit will obviously abate against the deceased plaintiff, and the defendant on application can be awarded costs that he had incurred in defending such a suit. And how will you recover? If it is a sole plaintiff, nobody came in time to be actually be made party, the legal representative to be made party, and the suit has awaited, defendant can say that no, I unnecessarily wasted time, money and energy over here, so court can award them costs, and that will be recovered from the deceased plaintiff's estate. Now we are seeing rule 3 we saw when there was the death of one of several plaintiff or sole dependents. Rule 4 is about here, that if a sole dependent dies, right to sue is surviving, or several dependents, it does not survive to others, then here on application, legal representative of deceased can be the party and proceed with it. Any person who is coming and making this, whoever is being substituted here, whoever will make defense should be appropriate to the character as the legal representative of the deceased defendant. If no application is made by the plaintiff, then obviously the suit will abate in respect of the deceased defendant. So obviously whoever is interested in seeking that relief has to put up an application that such and such person has died. Now I want to put this particular person, because the right to sue is not surviving to the other parties, I want the legal representative to be made a part. Now what happens? Court, however, whenever it feels fit, it can exempt the plaintiff from the necessity of substituting the legal defendant if that defendant had failed to file WS, or he had filed the WS but he did not appear or contest the suit, and that decision judgment will be pronounced against such a defendant, notwithstanding that the death of such a defendant had taken place, and we deemed that such a judgment was pronounced before his death. Now, in a situation where the plaintiff was only ignorant that the defendant has died, and he could not for that reason had made an application for substitution, time limit has also gone, suit has abated, then he may apply under Section 5 for admission under Section 5 Limitation Act that he did not know, and he had sufficient reasons why he could not make the application in time, and if the court feels so, it may consider such an application. Now, what would happen? Rule 5. Now, just think, we have seen when the right to sue survives, when the right to sue is not surviving, what will happen? Now, what happens if there is no legal representative only? Now, if there is no legal representative, then it will proceed in absence of a person, whoever is may proceed in absence of a person representing the estate, or an administrator general will be appointed, or an officer of a court, or any such other person for representing the estate will be appointed, and whatever decree or judgment will be passed will bind the estate of the deceased person as if a personal representative of deceased person had been made a party to the suit. Now, before any such order is made, court may require notice to all the people who it feels have an interest in that particular estate, and then from them also it can ascertain which person shall be appointed to represent the estate of the deceased person, and that person, it is very important that the court will take into note that that person should not have an interest adverse to the deceased person's interest. Now, next thing is rule number 5, which is talking about determinations of questions as to a legal representative. Now, it will always obviously be done by a court, like whether this person is a legal representative or not. This question is arisen. Who will decide it? Obviously, the court will decide it. If such a question is arising before an appellate court, before determining such question, the appellate court may direct a subordinate court that you try this matter, all records together will be given, all evidence, and whatever the trial court has recorded with its findings, reasons, all this will be considered by the appellate court when it is making such a decision. And rule number 6 is saying that if the person had died after the hearing concluded and only judgment was left, then here there will be no abatement, and judgment and decree will be passed to that effect as if it had been passed before his death. Now, this was for what is happening in the death. So what is happening in the cases of death? So obviously you have to understand if death is happening, right to sue, what is happening to the right to sue क्या वो सर्वाइव कर रहा है, क्या वो नहीं कर रहा है। अगर वो सर्वाइव कर रहा है, दूसरे को जा रहा है, तो उनके साथ लेके चलेंगे। नहीं जा रहा है, सोल प्लेंटिव था और नहीं और वो कर रहा है, तो चला जाएगा उनके साथ, उनके लीगल रिप्रेजेंटेटिव के साथ। अगर लीगल रिप्रेजेंटेटिव नहीं होगा तो कोर्ट अपॉइंट कर सकता है। एंड किस सिचुएशन में आपको कोई अबेटमेंट नहीं होगा, इवन दो द पर्सन हैज डाइड, यू आर सीइंग अंडर रूल 6 etc. So this is mostly in short and brief about what happens when there is a death of a party. Now the next topic that we go to is marriage. Now rule number 7 states that there will be no abatement by marriage of a female party, whether the female was in the capacity of a plaintiff or a defendant, or whether and where she was a sole dependent, and that there is something that needs to be executed against her, it will be executed against her alone. Just because she is married, it will not be executed against her husband also. However, if my husband is liable by law for deaths of his wife, then decree may be, with the court's permission, be executed also against the husband. And if it is in the favor of the wife, then the husband can also make an application for execution where he is entitled to the subject matter of the decree. So moving on to the next topic, that is insolvency. How will an insolvency of a party affect the suit? Now, rule number 8 is dealing with that, and it's saying where the plaintiff's insolvency is barring the suit. In general, it will not cause a suit to abate unless the receiver or the assignee who has been appointed is refusing to continue the suit or give security for the cost. Now, when they are doing so, then the defendant may again apply to the court that please award me costs, because I have incurred so many expenses in defending this suit and there has been no conclusion to the same. So this is how the plaintiff's insolvency will bar a suit. When in general it does not cause abatement, but when such a situation happens, it will cause. So assignment, rule number 10 is dealing with it. So where there is an assignment, creation or devolution of interest before the final order of the suit, then the suit with the court's permission can continue against such persons also to whom such an interest had been devolved or created. Now what in general? So we were seeing rule number 10, that is dealing with assignment. So if there's an assignment, creation or devolution of interest before the final order, the suit with the court's permission can continue against such a person to whom such interest was created, devolved or assigned, etc. Now these was under the, we saw the different topics, that is assignment, assignment, death, marriage and insolvency. Now we'll see the general rules that affect all of them. So rule number 9 is saying what is the effect of abatement and dismissal under such an order. If there is an abatement or dismissal under this order, no fresh suit will lie against the same cause of action. However, the person can apply for setting aside such abatement or dismissal by showing sufficient cause. And rule number 11 says that this particular order will also be applicable in the case of appeal. There, instead of plaintiff, you'll see the appellant. You just substitute instead of plaintiff, you substitute with appellant. In the case of a defendant, with respondent, and instead of a suit, you include an appeal. And rule number 12 is also saying that this order applies in the case of execution also. However, rules 3, 4, and 8 will not apply. So we can see what is rule 3, 4, and 8. You see 8 is for insolvency, and 3 and 4 is what? 3 is we go to 4 is in the case of a death of one or several defendants, etc. And third is about death of one or several defendants or of the sole plaintiff. So that will not apply to execution. So in short, if we see this particular order, we are seeing that how death, marriage, insolvency and assignment is affecting of a party, is affecting a particular suit or a particular suit. Now how death is affecting, we have to see with the right of suit. The suit, marriage of a female party is not affecting the suit in general unless there is some right created by law which takes the husbands into account also. Then insolvency in general also does not abate unless a receiver or signing is refusing to continue the suit or give security. Assignment, here also with court's permission you can continue against a person to such person who interest was devolved or created. If there is an abatement or dismissal, no fresh suit, but you can apply for setting that same aside. It also applies to appeals and execution. Now after this, now this was some topics that these were the 2 topics that I had to cover in the last class, but I could not cover. So now moving on to today's topic, that is special suits. I hope the above topics are clear that how they are affecting suits in general. Now we are moving to special suits. Now special suits are what? Here we are dealing with specific types of cases, certain types of cases. So the first type of a special suit that we'll be seeing is the suit by or against the government or the public officer. What are the prescribed sections in order? That is sections 79 to 82 and order 27. Now we have to understand one thing here is that this particular thing is not only giving us the procedure and the machinery. It is not telling us what rights or liabilities you can, what rights the government has or the public officers have, or what liabilities can are there. It is only telling you the procedure in cases where there is a suit by or against the government. So section 79 is the first section. It is telling that if it is a suit by and against the government, if you are having to make the central government party, then you use the name union government. If it is a state government, then use state of so and so, state of the state of Haryana, whatever you have to use the state of so and so. Section 80 is a very important section in relation to such topic, that is about notice. Now, no suit can be instituted against the government or the public officers, etc., unless 2 months notice in prior has been delivered. If it is a central government, then to the secretary to that government. If it is a central government relating to railways, then to the general manager of railways, government of Jammu Kashmir, the chief secretary or any other officer to the state government, any other state government, then the secretary to that government or the collector of that district. If it is a public officer against whom you have to file that suit, then deliver to him or leave it at his office. So very important thing, if it is a government, if it is a public officer, etc., here you first 2 months prior notice in writing has to be given to which official. You can see the list, which particular, if central government, then the secretary of the government, public officer, then you have to deliver it to his office, etc. What will be there in the notice? You'll state the cause of action, you'll state the name, you state the description and the place of residence of the plaintiff, whatever relief you're claiming, and you will also, in the plaint that you're writing, you will also say that a notice has been delivered for the same. However, this notice is a mandatory provision. Without this notice, no suit can be instituted. However, if there is a case where there is a need of immediate relief, then without serving this, the suit may be instituted, but the court here will see whether it is such an urgent immediate relief has to be granted or not. If there, and whether this can be done without giving the government or the public officer reasonable time, or the 2 months period is there. Now here, if the court, after hearing the parties, feels that there is no need of immediate or urgent relief, it will return the plaint for proper presentation. What is happening here? The court is telling, go give 2 months notice. If your work is not done, then come back. Now, if no such suit, now, if, for example, it is against a public officer in his official capacity, now that suit will not be dismissed on the ground that there was some error or defect in the notice. If the notice particular had a description, name, address, it was enough to identify who was appropriate authority or the public officer that person was meaning, and the notice was also left at the appropriate office, and the cause of action was also given, then that, just because there was some other defect or error in the notice, it will not be a ground for dismissal of the same. So section 80 becomes very important, that you have to remember notice, 2 months, which officer you have to remember, immediate, it is a mandatory thing, but sometimes for immediate relief, the court may allow you to do so. And defects as such, if these things are there, if it has description, name and other such particulars, then it will be not to be a ground to reject the same. Now, section 81 is talking that there is exemption from arrest and personal appearance. If those particular officers have done them in official capacity, then firstly, you would not arrest them or attach his personal property. And where the court is feeling their personal appearance is also exempted, where the court feels that he cannot appear in court without determining his job, without being it being a detriment to his duty, then his personal appearance will also be exempted. Now, section 82 is saying execution of a decree. This is also important. If it is passed against the union, state, or an officer in his official capacity, it will not be issued unless the same, whatever relief has been granted, remains unsatisfied for the period of 3 months from the date of order. It will also apply in the cases of an award or a decree. Now, what is the object behind putting such provisions, this 3 months for execution, 2 months for notice? Here, by giving the notice, we are trying to do so that government gets a chance to look into the matter and it feels that there are bona fide claims, etc., and it can settle it without going to court, that is done, and there is no expenses made. The government exchequer is not spent, public money is not spent on such litigations. 80 is a mandatory provision, and however, whatever acts are done in official capacity will not cover those acts of an officer which he has done in his private or personal capacity. And here, when you're computing the period of limitation, the period of notice has to be excluded. Now, what is the procedure? Where is the procedure defined? This there you'll see under Orders 27. I have not done it rule-wise. I'm just giving you a gist of it, that here the person can be authorized. There will be a special or a general order that this particular person is for this department, he'll be representing here. He'll be authorized to sign the plaint or a WS. Then they'll be authorized that you are the agents of the government, your address, etc. will be there. Who you have to be there, you have to follow under section 79. Now, government pleader is a person who will be the agent, who will be receiving the processes on behalf of the government. Whenever there is a time being fixed for personal appearance on part of the government, obviously any date is given to the government, the court will take into consideration that there should be a reasonable time enough, that communication within the government and instructions time should be taken for taking of instruction should be there. If any public officer, if against a public officer a suit is being made, being instituted, then this government is also joined in the same. And here the court can also direct for personal appearance of any party or any person which it feels can answer material questions. Now, time extension can also be given here. It is generally given quite liberally because they also understand this is not the only work the government officials are dealing with. So they can give them time to go make more references to the government. They can take all the legal consultations, whatever they want to take with the law officers, and they can come. And in a suit by or against the government, the first thing that the court tries always is to assist to come at a settlement. If there are settlement chances, it will adjourn and let the same happen. And here there are no requirements of security also. And under the Order 27, you can find the definitions of government and government pleader. So one of the most important special suits is suit by and against the government. Here, remember the 2 months notice, 3 months for the execution before the execution can start. What is the order? Who are you giving the notice to? All these things are important. And this is one special suit that we are covering. The next thing is that this is a short one, that is suits by and against the corporations that have been dealt under Order 29. Now, I hope I don't need to explain what is a corporation, etc. That is, I have not dealt that in detail. So we can move on directly to the rules. So who will subscribe or verify a particular pleading? Here the secretary, director, or any other principal officer will do the same. Whoever is able to depose on the facts of the case will do the same. How will this service will be done on corporations? You can do it on the secretary, director, principal officer, or leave it or send it to the registered office by post. If it is no registered office is there, then to wherever it carries on business. And third, if it feels that there's a personal attendance, court feels that is required, then it will be that person may be called for doing so at any stage of the suit. Now, the next order that we're dealing with, the next special suit is suits by and against partnership firms. This is Order 30. Now, Rule 1 states simply, if I am suing under the name of the firm, there are 2 or more persons who are liable as partners where the cause of action has accrued, then any party to a suit can apply to the court that who are at the time of accrual of the cause of action, who were the partners of this particular firm at that point. And any one of the persons who are saying that I am liable as a partner can verify or sign the documents or pleadings on behalf of all the persons. Now, rule number 2 is saying disclosure of the partner's name. Then if on demand by the defendants, the plaintiff or the pleader will have to provide a list in the name and address of the parties. If they are not doing so, the court will stay the suit. If the names are declared, then they'll proceed as if they were made plaintiffs in the main suit, even though the suit will continue in the name of the firm. But the name of the parties should also be added in the decree. Now, rule number 3 is talking about how the service of summons will take place. When it is in the name of the firm, You can do it on one or any of the partners in whichever place they're carrying out business, or wherever the control or management is there. If you are sending a summons there, it will be deemed as good service. Now, if a partnership was dissolved before the suit was instituted, then the service is made on all persons within India whom it is service. It's assuming to have been made liable, all those persons who can be made partners. Now, what happens if there is a right of suit on the death of a partner? If there is death of one of several persons before or during the pendency, no need to add it is not necessary to add the legal representative. However, the legal representation, it does not affect the right of the legal representative to be added to the party to a suit or influence any claim against the surviving partners, etc. Now, what capacity will the notice be served? Now, there's a service being done, that every person to whom it has been served will inform by a notice in writing that how he was, in which capacity he was served, whether as a partner or as a person who was in control or the management of the business. If he is not specifying so, it will be taken that he was served in the capacity of a partner. Rule number 6 is saying how will be the appearance of the parties. When they are appearing, they appear individually in their own names. They do not say, I'm appearing on behalf, I am such and such partnership, I am so and so, but all proceedings continue in the name of the firm only. Now, rule number 7 say that if a summons has been issued to a person who has control and management, who was not a partner, but he was only having the control and the management, there is no need of appearance necessary unless he is the partner of, he is being sued as a partner of the firm. Rule number 8 is saying that appearance under protest. Here, if I was, for example, I am under the control and management of a particular partnership, I was served a summons and it was assumed that I'm a partner. Now, I may enter an appearance into the court that I was never a partner at any material time, and now whoever person or plaintiff, whoever has made such an appearance before the hearing and final disposal, will apply to the court to determine whether I'm a partner or not. And if I am determined that yes, I was a partner, then this does not preclude me by setting up a defense that there is no liability of the firm. However, if I was not held as a partner, this is not precluding the plaintiff from serving a summons on the firm and proceeding with the suit. However, it can only sue that particular person in respect of the liability, not me, because I have been adjudged as not being a partner. Now, what will happen in the case where there is a suit between co-partners? Here also the same order will apply. However, no execution can be ordered without the leave of the court, and you have to take, on application, you have to take so, and all accounts, inquiries, etc. can be taken. Now, rule number 10, if a person is carrying on business in name other than his own, or HUF is carrying on business under a particular name, this particular order will also apply as if that particular name or the firm name, whatever you're using, was like a partnership. So this particular order 30 was dealing with a partnership firm. Very general ideas, very logical ideas, that if it is in the name of the firm, it will be taken against them. Now, if it is being done, then a list may be asked for it. If a disclosure is being done, if you are not disclosing the same, you have been asked to do so, then obviously stay can be done. And if the disclosure has been made, then the names of the parties will also be added along with the firm. How will this service of a summons takes place? What happens when such a partner dies? One partner dies, does a legal representative need to be added necessarily or not? What is the capacity in which you are serving the notice to? Which person in which capacity you are serving? Why is it important? Because if it is in control or management, then he is not required to come for summons, etc. And what is rule number 8, appearance under protest, and rule number 9, talking about co-partner suit between co-partners, and 10 about the HUF carrying business under a particular name. So I hope this order 30 in relation to a partnership firm is also clear. Now we move on to another important order, that is suits by or against minor or lunatics. This is dealt under order 32. Now, in general, you have to understand any minor, unsound person, all of these minority, unsoundness, etc. All these are legal disabilities, and the court or the law recognizes that they are unable to make decisions on their own, and this is why they have made, in this particular CPC, we find a separate order for them. Now, rule number one, we'll first deal with the or will all the rules that are dealing with the minor. There's only one rule which relates with the unsound person, which talks about what all rules of the minor are also applicable in the case of a unsound person. So first, starting with rule one, whatever suit is instituted by a minor, it has to be instituted in his name by an ex-friend of a minor. Now, who is a minor? Not attained 18 years, or if he has a guardian person, etc., is appointed 21 years. Now, what is the importance of rule 1? Rule 2 states that if it has been instituted without a next friend, plaint will be taken off file. Defendant can apply for cost against such persons. Now, notice. Then after that, we see rule number 2A, security to be furnished by next friend when so ordered. Then here, at any stage of time, court may order for recorded reasons, payment of costs, etc. Rule 3 states that guardian of suit to be appointed by court for minor defendant. Such order may be made by an application by the minor or by the plaintiff. If when there is a minor defendant here, there may be a guardian appointment by the court, and such for the same application can be made by the minor or the plaintiff. Now, this application should also have an affidavit saying that the particular person who wants to be made the guardian has no interest averse to the interest of the minor and is a person fit to be appointed. And no such application will be heard and order will be made without giving notice to a guardian who was appointed or declared by a competent authority. If there is no such guardian, then first you notice the father. If there is no such father, then you give it to the mother. If there are no father and mother, then you give it to the natural guardian. If there is no natural guardian, then the person, whoever is taking care of that person, will be called to check whether he has any objections to any other particular person being appointed there. In such a situation, notice can also be issued to the minor too. And whoever is appointed here will continue throughout the proceedings unless he is retires, removed, or he dies. And this continuation will also be in appeal, revision, and execution. Now, Rule 3A is stating that decree against a minor will not be set aside on the ground just by showing that the person, the next friend or the guardian, had an adverse interest. On that ground, you cannot get a decree set aside unless you can show that that particular adverse interest has caused prejudice to the minor's interest. And this particular rule will not preclude the minor to go separately and ask for relief for misconduct or gross negligence on the part of the guardian or the minor in respect of this suit. Now, rule number 4 says that the person should be sound and major to be acting as a next friend or to be appointed as a guardian, and provided his interest is not averse and he is not the opposite party in the case. Even though I do not have an adverse interest to you, but I'm the defendant of the case, that will not allow me to become a guardian for such a minor. Now, once there is a next friend or a guardian, no other person can be guardian, then no other person can be allowed to do anything in regard of the same unless court records that there is a need for substituting such a person. And no person will be appointed as a guardian without the consent in writing by such a person. Now, if there is no person that the court finds is willing to do so or is fit for this thing, it can appoint an officer in regard, and who will deal with the expense. It can be by the party or the parties or out of the minor's property. So who represents a minor is always represented by a next friend or a guardian of a suit, a guardian in a suit. Now, Rule 6 is saying that receipt by next friend or guardian for the suit of the property under the decree of the minor. Now, here, without the court's permission, they cannot receive any money, movable property on behalf of the minor, or enter into any compromise, etc., or get any order, decree, anything of such sort cannot be done without taking the court's permission. Now, where no such appointment has been made or the person is under the disability, then he may grant him leave that when he feels that there's no such problem, then he will be granted leave to receive the property and all other directions that the court may give in this regard. Now, court may also record reasons why it is dispensing with security and why it is allowing it to do so, etc. However, in cases if there is a manager of a Hindu undivided family and the particular property is relating to property or business of the family or the parent of the minor, in that cases the court allows. Now, rule number 7 is saying any agreement or compromise by the next friend or the guardian of the suit needs the court's permission, and the same has to be expressly recorded. And whenever the same is done, again give an affidavit that this thing is beneficial for the minor. Court can examine on this point. If no such permission is taken by court, this particular agreement or compromise is taken as voidable except as against the minor. And rule number 8 is saying that if there is a retirement, first you procure a person who's fit for taking your place, only then you can retire. And whoever the next person is coming, again has to give a document in support, affidavit in support, that I am fit, I have no adverse interest, etc. Now, rule number 9 is talking about removal of next friend, where if there is an interest reverse, or it is unlikely that the person will be able to protect the minor's interest, or he is not doing his duty, or during the suit's pendency, that person is ceasing to reside within India, or any other sufficient cause is shown, then the application can be made by the minor or the dependent for his removal, and court, if is satisfied on the same, can pass an order for his removal. Where the next friend is not a guardian, then the guardian can apply for being appointed, and the guardian can apply, and the guardian should be appointed unless the court feels so that these are particular reasons for which they should not be appointed. Then record the reasons and do the same. Now, rule number 10, there will be a stay of proceedings on removal, etc. of next friend till, if there is a removal, anything that has taken place, removal has taken place, or there is a death, the retirement, etc. till the next friend has been appointed, there will be stay of proceedings. Now, rule number 11 is obviously saying the same thing. If the pendency, something like this is happening, removal, retirement, death, new person has to be appointed. Now, rule number 12 is the most important rule. This can be said where the minor is trying to get the right of election. That is, when the minor plaintiff or applicant has attained majority. Now he has the right whether he wants to continue with the suit or application, or whether he wants to abandon it. If he continues it, then he'll apply for discharging of the next friend and proceed in his own name. And now the suit title will read that such and such late a minor, like previously he was a minor who was represented by such and such person who was his next friend, but now has attained majority. This would be the title. This is the exact wordings that will be used in the title of the suit. Now, if this minor says that I want to abandon, he's decided to abandon the suit, and he's the sole plaintiff or applicant, he'll apply for order of dismissal on repayment of costs, etc., whatever was incurred by the defendant or the opposite party, which may have to be paid by his next friend. Now, rule number 13 is saying when the minor co-plaintiff attaining majority decides to repudiate a suit, he'll apply. He does not want to be a party to the suit anymore. He'll apply to the court that please strike out my name. And if the court feels so that yes, he's not a necessary party, it may order his dismissal. And for the same application, notice will be given to the next friend and the dependent. Where he is a necessary party, then there the court can direct him to be made a dependent. And the cost of such application will be paid by such person, whoever the court directs. Now, rule number 14 is saying that if it was an unreasonable or improper suit and the minor on attaining majority, if it can apply that this suit which was instituted by his next friend, then it can be dismissed on the ground that it was unreasonable or improper. And here the notice has to be given to all the parties concerned. And the court, if satisfied that it was unreasonable or improper, may also order the next friend to pay costs. So this was rule number 1 to 14, where we're dealing with what will happen in the cases of a minor, how will we deal with the case of a minor. And rule 15 becomes important. Why? Because it tells that rules 1 to 14, except rule 2a, is applying to a person of an unsound mind, or a persons who have not been adjudged as unsound but have on inquiry found to be incapable. So under here, where we saw order 32, we saw first that yes, you have to, for a minor, there should be a next friend in the name of the next friend. If it is not there, then the file will be taken off. Then this who will security needs to be furnished by the next friend. This particular rule 2a will not be applicable in the case of an unsound person, but otherwise it will be there. Now, rule 3 is about appointment of a guardian for a minor defendant. What will happen when he'll be there? And whenever there is any appointment, etc., obviously in that place, wherever there's application that a person is making that I want to be a guardian or be the next friend, always an affidavit that I do not have anything in regards to the interest of the minor, I am a fit person, etc., has to be made. Now, what are the grounds where a decree, if it is passed against a minor, cannot be set aside that on the ground only that there was an adverse interest, unless you can show that yes, it has caused certain prejudice to his interest. Then again, who can be a guardian or a next friend? Who can be a next friend? Sound mind is important. He should be a major. He should not have an adverse interest. He should not be the opposite party in the case. He should give his consent in writing. He should. And if there is no other person, then the guardian will be there. If the guardian mostly is allowed to do so, unless otherwise, then they'll be representing the suit, whether they can compromise, etc. What will happen if they can compromise or enter into agreements, etc. Retirement, death, removal, in all these situations, until the next person is appointed, till then, the proceedings will be stayed. Rule number 12, very important. What happens when this particular minor is attaining majority? What will happen if he abandons it? What will happen if he continues it and he wants to repudiate it under Rule 13? If it is an unreasonable or improper suit, then what will be done? And Rule 15 is dealing with the unsound person. I hope the rewind was enough for this particular order on this particular special case suit that is relating to minors and unsound persons. Now moving to the next important order, or the special suit, that is an interpleader suit, which is dealt under Order 35 and Section 88. Now, what is Section 88 is telling us the essentials for an interpleader suit. Now, in an interpleader suit, basically there are three parties. There are three parties, one plaintiff and two or more defendants. Here, the plaintiff has no particular interest in the subject matter, etc., except for the charges of cost. He is saying simple reason that okay, I am filing this suit because these are the persons who are contesting against each other that I should get this property or I should get this sum of money, etc. Now, please decide and tell me who I have to give this money. I do not object to giving this money to, but please tell me who I have to give this money. So, according to Section 88, if there is a debt, sum of money, movable or immovable property in dispute, that is the first thing. What should be in dispute? Any of these things must be in dispute. There must be two or more persons who are adversely claiming against each other, and the person against whom such a debt or anything is recoverable has no interest in the entire thing except the charges and the cost, and he is willing to pay to the rightful claimant. Then there is no other suit which is pending where the rights of the claimants can be properly adjudicated, then you can file an interpleader suit. So there should be sum of money, etc. Two persons must be adversely claiming, and this person is not at all interested in who gets it, what gets it. He's only interested in the charge of the cost, and he wants to pay the money. There is no suit pending wherein the rights of the claimants can be properly adjudicated. So where under Order 35 we see what will be there. So under Order 35 Rule 1, we are seeing that the plaintiff in the interpleader suit, other than the plaintiff, will also state that I have no interest in the subject matter except for charges of cost, and that there is no collusion between the plaintiffs or any of the defendants. Rule number 2 is stating that if the court feels that there can be a payment of thing which is being capable of being paid or put in custody of the court, then the plaintiff will be required to do so. Now, what is the procedure where the defendant is suing plaintiff in respect of the subject matter of the suit, and this suit is pending against the plaintiff? Then that particular suit, the court where such a suit is pending, that will be informed that an interpleader by the court where the interpleader was instituted, that please stay the proceedings against him, and decision for cost also can be made. So if what happens, like for example, I have to pay a particular debt to a particular person. Now the persons who are saying that amount should be payable to me are three persons, and one of the three persons had filed a suit against me for recovery of the amount in another court. Then if I have instituted an interpleader, then the court where I had instituted the interpleader will go and tell that court that please stay these proceedings, because now we'll decide whether this amount is actually even being capable of being paid to him or not. Now, rule 4 is the procedure of first hearing. Now, at first hearing, the court will declare that the plaintiff is discharged from all liabilities of the thing claimed. He'll award him his costs, and he may dismiss the plaintiff that, okay, your work is done. You are discharged. You go. We'll see what to do next. Who will be awarded the fee. But however, the court feels that it is necessary for justice or convenience, then that all the parties may be retained till the final disposal. Now, if any admission or evidence has been made, then adjudication of the title in respect of the same can be done. If they are not enabling the court, these admissions or etc. not enabling the court to adjudicate, then it may direct that issues be framed, etc. and then it will be tried, and the claimant will be made a plaintiff in additional to the original plaintiff, and it will proceed in an ordinary manner. Now, there is, however, a bar, that is rule 5. There is a bar on who cannot file, who can file such a suit. Now, that is two important criteria persons, agents and tenants. These cannot institute or interpleader against the principals or the landlords. They can never come and say that I deny the authority of this landlord, that he is not the landlord, this person is the landlord. They can never do so. There is a bar that an agent or a tenant cannot institute or interpleader. So this is a very important part. You have to remember this. And rule 6 is charged for the plaintiff's cost. That is there. So interpleader suit, that is dealt under order 35 and 88. I hope the concept is clear here. The plaintiff wants to pay the money, but he does not know who to pay to. That is why he has filed an interpleader suit, not for a dispute between him and the defendants, but between the defendants. So there's a sum. So you can understand there's a sum of money, debt, movable or movable property in dispute. They're adversely claiming. He is ready to pay. No suit is pending. Now, what will he write in the plaint? That is given. He can even be asked to pay that thing in court and leave. And when he is suing the plaintiff in another court, then what will be done in that case? What will be done in the first hearing? He'll be heard, he can be dismissed, or it may be continued. If the adjudication of title on the basis of admission or evidence can be done. If it is not done, then he'll frame, etc. Rule 5, very important, agents and tenants cannot institute interpleader against their principal or their landlords. So this was for interpleader suits. Now we move on to suits by indigent person. That is order 33. Now rule 1 states that a suit can obviously be instituted by an indigent person. And who is an indigent person? That person has either does not have enough capacity to pay the court fees or any other fees that is attached to such a suit, or if there is no court fee prescribed as such, then that person has no property worth more than 1,000 rupees. And how do you calculate that 1,000 rupees? You will exclude all those properties that cannot be attached in execution. So you remove those exempted properties and then calculate whether 1,000 rupees worth of property is left with him or not. Now, any property, if he has he has presented an application that I am an indigent. Remember, he has presented an application that I am an indigent, and after that, here there's an application. He's not presenting a plaint. He's presenting an application that I am a indigent person. Please remember this. Then any property is acquired afterwards, the institution can also be considered for deciding whether he's actually an indigent person or not. Now, Rule 1A is stating that every inquiry, whether this person is indigent or not, will be made by the Chief Ministerial Officer of the court, and who will make a report, and on this particular report only, the court will act upon. Now, what would be the contents of this application? Not a plaint. It is an application. You are making an application to sue as an indigent person. In that application, you're writing all the particulars of a plaint. You're writing the schedule of movable and immovable property that belongs to you, and you're signing and verifying it. Now, 3, this presentation of application shall be done in person unless you're exempted from personal appearance under any other provisions of the court, etc. In that case, an authorized agent will present the same, and he should be able to answer the same, or he should be accompanied by a person who will be able to answer the questions relating to the same. If there are more than one plaintiffs, then even if one of them have come, then it is enough with the application. One of them is enough, they can appear and do so. Rule number 4 is talking about examination of the applicant. If the application was properly presented, then the party or the agent will be examined, and Then and if it was done by an agent, the agent was examined, but the court feels so that the person needs to be examined and you are an exempted person, etc., then the court can also send commissions for the same. If you can remember in the last class, we had seen when a commission is being ordered. Now, important rule, next one is, that is rule 5, where such an application will be rejected. First thing, when the application is not in accordance to rule 2 or 3, you have not written the contents of the application, or you not presented on your own, the applicant is not indigent, whether within 2 months before you presented such an application, you had fraudulently disposed of property, or you had for getting such a permission, you just disposed of your property, and where your allegations are not showing any cause of action, where you have entered an agreement into the respect of the subject matter where another person has also obtained an interest, if the suit in itself is barred by law, or you have entered into an agreement with another person to finance the litigation. So rule number 5, important in respect of what are the grounds in which your application for being an indigent person will be rejected. Not in accordance to rule 2 or 3, you are not indigent, 2 months prior you disposed of property fraudulently or for getting such a permission, or where your allegations have no cause of action, where you have entered an agreement with respect to the court subject matter with another person who has obtained an interest, suit is barred by law, or where you have entered into an agreement with another to finance the litigation. The rule number 6 is saying that in respect of your indigency, evidence has to be taken and no rejection has taken place. At least 10 days clear notice will be given to the opposite party and the government pleader so they can prepare the case for receiving the evidence, and the applicant will produce it, and then the court will hear it. Now, rule number 7 is saying on the day fixed or whenever it is, court will examine any witnesses that any of the parties are producing. The person himself or his agent will be examined, or a statement will also be recorded. Here, however, you will see there under rule clause B, C, and E of rule 5 only. If there are witnesses examined, then they'll examine on the point of B, C, and E of rule 5. That would be B, C, and E would be if there is indigent or not, 2 months prior he had done that or not, or whether the allegations have no cause of action, that can be done. And if it is a party, then all matters under rule 5 you can examine on the same. Now, arguments can be heard on the face of the application or the evidence. Court can, may, and or may not allow a person to sue as an indigent. Now, rule number 8 is talking about procedure if the application is admitted. If admitted, you are allowed to sue as an indigent. The number will be given to you. You can register. And that application that you have presented, it is an application. It was not a plaint. It will now be deemed as a plaint in respect of a suit. Now, only thing that will be left, that you are not required to pay a court fees because you have been allowed to sue as an indigent. Now, rule number 9 said that obviously it does not mean that just because a permission has been given to you to sue as an indigent, it can continue for forever. If on application of the defendant or the government pleader, 7 days clear notice is already also given to you, there a withdrawal of such a permission can be done if you have shown that you have vexatious or improper conduct during the course of suit. It appears that you now actually have enough means that you do not need to be continued as an indigent, or you have entered into agreement with the subject matter where another person has obtained an interest. And rule 9A, if you are an indigent person, you can't have a pleader, legal aid principles, the court can assign a pleader. And order 44 is dealing with appeals by an indigent person. So this order 33 is dealing with suits by an indigent person. Who is an indigent person? You have to understand who makes the report on who will be an indigent person, what will be the contents of an application, who will present such an application, how will this person be examined. Rule number 5 important, that when can such an application be rejected. Then after that, what is the notice to be given, what will be the procedure, what will happen if it is admitted, whether there can be a withdrawal of permission or not, etc. So I hope with this particular order, please remember that application part, that it is always this particular suit by an indigent is always, we'll always give an application, not a plaint, and later on if it is admitted, it is deemed as a plaint. Now this was for indigent persons. The next we'll move on to is summary suits. Now what are summary suits? That has been given under order 37. Here also I have not dealt with the entire rules as such. We'll just go through it Yeah, indeed. Now, where does this procedure apply to? It applies to high courts, city civil courts, courts of small causes, etc., or other superior courts. In what suits are summary suits to be taken place? In bills of exchange, hundis, promissory notes, or where there is a debt or a liquidated demand of money with or without interest arising out of a written contract, enactment, guarantee, etc. So, in general, if you understand summary suits, you can understand where the court will try to get rid of its lengthy procedure in situations where there is a very definite cause of action. Like if there's a bill of exchange, you know it either there's a payment or there's no payment, etc., or you're denying, etc. Where there is a liquidated demand of money, where there's a debt with or without interest arising out of a written contract, etc. So you can logically try and conclude that where the court may, if you are a court, if you have to apply a summary suit procedure, obviously you'll not apply in a case where there's a title dispute. You'll apply it in a situation where there is there's not much requirement of such an elaborate procedure. Now, whenever a plaint is presented under such an head, under Order 37, you have to mention that I am instituting a suit for which should be governed by Order 37. I am claiming no other relief. And when the summons is being sent, here the summons is not being sent for the defendant to come and defend it. He does not have a first right to defend it. He can, if he can come, he appears before the court and he says that I am denying the same and I want to defend this particular suit. I want to defend this particular suit, then only he can defend the same. If he is not appearing, then he deem that he has admitted whatever is there, and the court accordingly will decide on the merits, whatever, that whether the decree should be awarded with interest, costs, etc. Now, when the summons is being sent, all plaints, all annexures, all relevant documents is also to be sent to the defendant. Within 10 days of the service of such a summons, the defendant can either appear in person or by a pleader. He can file his address for service of notice, etc. And if all that is done, then it will be a deemed that the process has been served properly. And on the day the defendant is appearing, notice will be given by the defendant to the plaintiff, pleader or plaintiff by notice or a paid letter. And after he has appeared, he'll be served summons for judgment. And within 10 days after he has appeared, he has to bring an affidavit, or otherwise he has to disclose all those facts which show that he is entitled to defend this particular case. He will apply for the leave for defending the same. Court may grant the same if it deems fit, and or unconditionally it can be granted the right to defend, or on certain conditions he may be granted. And if there is a refusal of such relief, there's such relief that of allowing him to defend, it will be when there is no substantial defense or with just frivolous or irrelevant defense, then the court will not allow him to defend. If there is a part of the amount that a defendant has appeared and said that I admit this particular amount, then what will happen is that first that defendant has to pay that particular amount. If he does not do so, he will not be allowed the leave to defend. At hearing of such summons for judgment, if leave was not made or if the leave was refused, the plaintiff is entitled to the judgment. But if the leave was allowed, then the court will first hear him or may direct him to give security, etc. And if he doesn't follow the court's direction, the defendant, then the plaintiff will be entitled to judgment. Now, if there is a delay in entering appearance or leave and he comes up with valid reasons, it may be condoned. And Rule 4 is the power to set aside a decree in special circumstances. And if again, where the decree was passed without his appearance or without giving him the leave to defend, in special circumstances, such a decree can be set aside and he will be granted leave to appear and defend the suit. You can see Rules 5 to 7 in this case. However, it is important to understand the distinction between a normal and a summary procedure suit. What are the distinctions you have to see? The first distinction you have to see that what clothes it applies to, you have to see that. So coming back here again, the summary suits part here, you have to see whether who does it apply to, what are the suits, what is the subject matter, what should the plaint contain, who, if the summons is there, here the summons is not sent to the defendant for defending the same, first he'll appear and then he'll take the leave of the court to defend. All this has to be taken in account. You have to contrast it with a normal procedure that you have seen previously and how it is different here. Can be asked the distinction between the two. What is Order 37? Can this be? Can it be that Can it be that such a decree that has been passed can be set aside or not, etc. So this is all about summary suits under Order 37. I hope that is clear. Now we move on to the last sections, that is suits relating to public nuisance, section 91, and suits relating to public trust, section 92. So section 91 is talking about if there is a public nuisance or any other wrongful act which is affecting or is likely to affect the public, a suit for declaration, an injunction, or any other relief will be instituted by whom? This is an important part because this is a little peculiar in comparison to the entire code. Because here, the right to institute such a suit is to the Advocate General first, or two or more persons who take the leave of the court, even though they have no special damages caused by them by such public nuisance or wrongful act, then they can do so. However, this section in any way is not limiting the right of such persons to go independently and sue or file a suit, but for under the heading of a public nuisance, Advocate General or two or more such persons who will take the leave of the court, even though no special damage has been caused to them. Now, public nuisance again is not defined under the code, but under section 268 IPC, you can take that definition and you can read here. Now, what are the remedies for public nuisance? You will see under IPC. Then magistrates can do so by using their summary power. You can file a suit under section 91 CPC, or you can file a special suit for special damages can be filed by a private individual. I hope that is clear. Here, the most important part is who can file such a suit. Then, moving on to suits relating to public trust, that is section 92. Here, if there is a suit where there is a breach of trust, which was created for a charitable or religious purpose, here again, the right to institute such a suit is to the Advocate General or two or more persons who has an interest in this trust can file the same. Where will they file it? In the principal civil court of ordinary jurisdiction or any other court where whole or in part this subject matter is situated. Now, suit here, whichever suit here is being filed, it will be behalf on all of the persons who are interested in the trust, and the beneficiaries are choosing who are representing them and those persons who become the plaintiffs. As it is a representative suit, here also res judicata will apply against all of them. Now, firstly, for coming under this section, you have to show that this trust was created by religious or charitable purposes. There was a breach of trust or there was a direction of court for administrating the trust that was breached. Now, the reliefs, whatever has been claimed, must come under the category of reliefs that has been given under section 90. There's a long list where there can be removal of a trustee, appointing of a trustee, vesting any property in a trustee, etc. You can go through that list. Only those reliefs can be claimed here. And doctrine of Cyprus is also applicable. Cyprus means as far as possible. Like, for example, whoever had created the testator, who had created the trust, might have given his intentions or his guidelines that this is how I want the trust to be done. It may be possible that in most of the times, all of them strictly cannot be applied. But in that situation, just because you cannot do all of it, doesn't mean you abandon the same. You should try as much as possible. So the court would also see whether the doctrine of Cyprus is being applicable in this case or not, is being used in this case or not. So this was relating to suits relating to public trust under section 92. Here you should see what are the category of reliefs under section 92, what are the different reliefs that they can ask for. Again, important, who can file this suit and where can it filed, and it works as a res judicata against all the persons who are being represented. Now that was mostly the last part. However, we'll just see what is a special case or a friendly suit. This is dealt under section 90 and order 36. Here, in this case, I have not gone into the section, I have not gone into the order into a detail, but you can see that here the parties are not coming with the plaintiff. The only thing they are interested in is that they have come with a question of fact or law and they want the court to please decide this particular thing for us. We are friendly with each other. They have entered into an agreement. They have stated the question in the form of a case. They only want the court's opinion. Court thinks fit that it should give an opinion. They can decide the same. Now, whatever agreement these parties are entering, it should be duly executed, and the parties should have a bona fide interest in the question, and the case should be fit to be decided. And if a particular case has been decided or friendly suit has been decided, no appeal lies here because it is a consent decree. You have come on your own, etc. Here, friendly suit is like the parties are not at swords with each other. They are not fighting each other. They just have won a decision in respect of a particular question of fact or law. Now this was another kind of a special suit. And then there are others that you can see against trustees, executors, administrators, or interpretation of constitution, mortgage suits by aliens, etc. These are some other orders which are also special suits, which if you want, you can go through them. I do not feel I do not think that they were that important, so I have not dealt with them here in detail. You can go through them if you want. So with special suits, we first went on and covered suits by and against the government. As you have we have seen, you should remember the notice and the execution part, or you have to give notice. All these can be questions for your MCQs or for there. So this was for your suits by and against the government. Then we went on to suits by and against a corporation under Order 29. Then we saw suits by and against a partnership firm. After that, we went and saw for minor and lunatics. Moving on to the next special suit, which was interpleader suits. Then we went on to indigent persons, and then summary suits, public nuisance, trust, public trust, and in the special case of the friendly suit. And then you can go through them all. Now, this would be the end of the class. I hope you could understand what are the different kinds of the suit, what are the important suits. Please try and remember the order numbers, section numbers that are involved. If there's anything very peculiar, like for the government one, I said about the execution and the notice, try to remember those such details. Now, this was all for today's class. I hope there is no problem as such. If there is any problem, please let me know. As usual, please let me know if there's any problem, and do review the entire lecture. We'll be dealing with appeals, reference, review, revision, etc. in the next lecture, and try and cover this entire chunk in the next lecture. So this is it for today. Thank you, and please do share your valuable feedback. Thank you again.